Welcome one and all to the Mediate Gurus International webinar on interim relief in international arbitration. Mediate Guru is a social initiative led by members across the globe. The aim of the organization is to bridge the gap between the general public and litigation. We are creating a social awareness campaign for showcasing mediation as the future, having successfully conducted various international webinars promoting alternative dispute resolution, having a reach in more than 100 countries around the world, with an international family growing each day. We strive to provide you the best lecture series through the best speakers around the globe so that you have a value addition today. I feel honored today to welcome our esteemed speaker for today's session, Ms. Uliana Cooke. Uliana is a partner leading the international arbitration practice at PCB Bryan LLP based in London. She has acted as counsel in international commercial and investment treaty arbitrations, including under ICSID, UNCITRAL, LCIA, ICC, and SIAC rules, as well as in ad hoc arbitrations emanating from the CIS region, Africa, Asia, and the Middle East. Uliana is admitted as a teaching fellow on the International Arbitration LLM program at Queen Mary University of London and a professor at Perical Law Centre where she teaches international commercial arbitration. I would request Ms. Uliana to take the session forward and enlighten us all. You all can ask your questions in the chat box.
Hi, everyone. Thank you so much for this wonderful introduction. And thank you very much for the invitation to present to all of you today. Greetings from London. And I just wanted to start this session possibly with a few remarks of my own. You know, I joined PCB Bryan in London, the firm that is number one in obtaining interim relief from English courts, including worldwide freezing order and extraordinary interim measures from courts around the world. And it made me think, what about international arbitration? You know, although I have acted as counsel in various cases before tribunals, you know, how customary is it to obtain an interim measure from the tribunal? How are the tribunals behaving when such applications are launched? Do they have enough confidence to issue interim measures? What about counsel? How do they approach this application? You know, is there a particular guidance how to do it? And of course, the students will be aware that in international arbitration, it's a world of various complexities involved, including the law of the seat, applicable arbitration laws, institutional rules, the parties' agreement. How does one navigate in a complex international arbitration proceedings? So that really preoccupied me and sort of my thinking in assessing the current status, looking back also at my experience. And I would like us to, approach this topic with the following thought in mind, the question in mind: is international arbitration well equipped to deal with applications for interim relief? So to start with, I just want to set the outline for today's presentation. So we will be discussing the purpose and types of interim measures that are known to the practitioners. We will be asking the question where to seek interim measures. Then we'll be proceeding to the question of the powers of the arbitral tribunal, and does the tribunal possess sufficient power to grant interim measures? Then we'll think a little bit about the role of emergency arbitrator that, has been emerging through the years and now quite well known and adopted as a mechanism in institutional rules. And also to conclude, we'll think about the enforceability of interim measures more widely. So, as you may be aware, that interim measures may be ordered by arbitral tribunals or national courts in support of arbitration, and ordinarily they be granted at an early stage of the proceedings. And they're called interim, or sometimes they're referred to as provisional measures, precisely for the purposes of, to reflect that opportunity for the tribunal to set aside that measure if it becomes necessary. So therefore, hence the name interim or temporary, usually ordered on a provisional basis. And ordinarily, interim measure will be in place, will be in force until a final award is rendered, simply because there may be no need at all, on conclusion of the arbitral proceedings in that. So that's quite a standard practice. The purpose is to preserve the status quo or protect assets. So, for instance, prevent dissipation of assets, or protect evidence, prevent dissipation of the relevant evidence, prevent hiding of the evidence. And so this measure, it is pending upon the resolution of the arbitral proceedings. And sometimes a type of an interim measure, can be a conservatory measure, measure preserving evidence or assets. But this is really, if we look into the classifications, there are various ones. And if we think about the purpose, though, coming back to it, as mentioned, there may be a need to protect the status quo. There may be an urgent need to preserve, to prevent conduct that may cause irreparable harm to a particular right. For instance, in the trademark dispute, there may be a need to prevent the release of confidential secret information, or prevent misuse of patent, a design, or a trademark. Potentially, there may be a need to prevent destruction of goods that is the subject matter of the dispute, or establish escrow account for earnings. And ordinarily, a party would think of applying for an interim measure when damages may not be an adequate remedy. So it cannot wait until the final resolution of the dispute. And you see on the screen the types of measures that we can divide into. Jumping to this slide, if one were to classify them in the mind, can think of negative orders, positive orders. Negative orders would prevent a party from doing something. Positive orders would, as implied in the word, would order something, would do something, produce a result, produce an action. So, for instance, among positive orders, there may be an order to keep records of sales of all goods manufactured. There may be an order to place money received from sales of licensed products in an escrow account. There may be a need to produce property records relating to licensed products. And apologies for jumping back to the slide. Examples of orders, positive orders, would also be an order requiring the evidence to be produced or delivered up into safe custody, or an order requiring your opponent to identify the whereabouts of that evidence and to ensure its safekeeping. As mentioned, this may be just to stop your opponent from destruction or hiding of the relevant evidence. Another type of order can be a conservatory order requiring the property to be produced or delivered in safe custody. Again, this is to prevent destruction, damaging, or hiding of that property that potentially is the subject of the dispute. And the aim is to preserve it safely until the dispute between the parties has been resolved. Another type of order can be an order requiring the sale of goods where an order in the context of the perishable goods, in other words, the goods that may deteriorate before the disputes can be determined. So, and the tribunal may order the sale of goods at this point, at the early stage of the proceedings, before the final resolution of the dispute, and the proceeds from that sale may be held again until the final resolution of the dispute. Another type of order can be an ancillary order requiring the goods to be sampled, tested, or photographed prior to that sale taking place. Then if we think about dissipation of assets, sometimes behavior of the parties, that it's not all nice and rosy and smooth, and some party would try and dissipate the assets so that there'll be nothing to enforce against at the end of the proceedings. So to prevent that from happening, we have a mechanism, and in England we call it freezing injunctions, that would prevent dissipation of assets and restrict certain parties from disposing of that particular assets. Then if we think about other types of orders, we can think of an order for security for costs. And this is in the circumstances that where the respondent party goes through all the way in the process and wins the arbitral proceedings, and only to find out, and in case of the total win and the award of adverse costs, in other words, of legal costs incurred in the arbitral proceedings, and in England and in other jurisdictions, the losing party pays. That's a general rule. And so the tribunal agrees with that rule, and the respondent has this wonderful adverse costs award, and and then only to find out that the claimant is impecunious and there is nothing to enforce against. So what would the respondent party do to prevent that from happening, from facing it at the end of the proceedings? Well, that's a security for costs order available, and the leading institutional rules these days expressly provide for it. We will look at the LCIA Arbitration Rules a bit later in the session. But these are the types of interim relief that are available. Again, injunctions, you can think of many various injunctions preventing a party from using trademark, confidential know-how, from selling products under license, from holding itself or its subsidiary out as an authorized licensee. You pretty much can ask for an order taking any other action affecting validity or value of a particular right in question. And where to seek interim remedies? So you have identified, say, as counsel for the claimant, the risks involved, and where would you go next? Well, number one is the tribunal, of course, provided that the tribunal has been constituted. If the tribunal hasn't been constituted, and depending on the applicable institutional rules, emergency arbitrator may be an answer. So these days, leading institutional rules such as the LCIA Rules 2020 or the ICSID Rules 2016 provide specifically for the mechanism of emergency arbitrator being appointed prior to the constitution of the tribunal to deal with requests for interim reliefs, for instance. And then another option would be to go to the competent national court, but that's the traditional role that a national court would play to support arbitration proceedings, right? And so that's, of course, always there. If we think about the arbitral tribunal and where does the power to grant interim measures actually come from? So imagine if you're an arbitrator appointed and a party is asking you for an injunction to stop releasing the know-how, for instance. So where do you look as an arbitrator? And where do you look as counsel as well? Well, first of all, there is an arbitration agreement. And these days you can have arbitration agreement drafted by arbitration lawyers. I know there's this preconception that it's a midnight clause and there is no much thought that goes into the drafting, but well, you may actually think about expressly including empowering the tribunal through the arbitration agreement to grant interim relief. Then you would look at applicable procedural rules. You'd look at applicable arbitration rules. You'd look at the law of the seat of the arbitration, because then it might have a mandatory overriding effect in relation to what has been agreed, and for the enforceability purposes as well, very important. But also potentially a party may want to seek interim relief from a foreign court in support of an arbitration, say, seated in London. So you'd need to look into the law of that national system as well. And then, of course, there is the tribunal's inherent power to conduct arbitration in accordance with its own discretion to run and conduct the arbitral proceedings in good faith. So that's an interesting one. And, of course, the question is how far would that extend? Within the relevant framework, the tribunal will need to assess the scope of its power. And we'll turn to just a few examples of the leading institutional rules, just to see the drafting of it. And I think, it's important to bear in mind when looking at any provision of any institutional rules, to bear in mind the drafter's intent, to actually understand why a particular provision has been drafted in that way, and potentially also looking back at the history of the previous versions of the rules. It may be quite telling because the rules have quite evolved significantly, and these days, arbitral institutions become more and more user-friendly. Of course, they have their interests. They want to assist all the users of arbitration. They want to be one of the top institutions to provide the relevant framework. So if we look at Article 25.1 of the LCIA Rules 2020, for instance, we see the following. We see that the arbitral tribunal shall have the power upon the application of any party after giving all other parties a reasonable opportunity to respond to such application and upon such terms as the arbitral tribunal considers appropriate in the circumstances. And then we'll have a list of types of measures possible to obtain. But we already have a pretty good idea of what types of interim measures are available there. What I'd like us to focus on is the first sentence, and that's something that is interesting. The rules expressly provide for the other party having a reasonable opportunity to respond to such application. Okay, so my esteemed litigation colleagues would tell me, but what about ex parte orders? What about, say, applying for a freezing injunction? You know, you wouldn't want to frighten the party and put them on notice. How does the international arbitration framework assist with that? Well, that is precisely one of potential difficulties that exists in international arbitration. As you know, there is the overarching New York Convention, under which the words are capable of enforcement in most of the world. And Article 5 provides for certain grounds, as you know, when such recognition and enforcement may be refused by the relevant courts. And one of them is Article 5.1b, that basically provides for a ground that recognition and enforcement may be refused if the other party furnishes the proof that the party against whom the award is invoked was not given proper notice of the appointment of the arbitrator or of the arbitration proceedings, or was otherwise unable to present his case. So with this provision in mind, and think that the New York Convention was drafted in 1958, so it's actually a long time ago, you know, the arbitral tribunals, there is a valid issue in arbitration of how to deal with ex parte orders, because then, you know, would that, if I as an arbitrator grant that order on an ex parte application basis, what would that mean for the finality and the enforceability of my award? Well, you know, here's Article 5.1b that creates some complications and may render the award unenforceable on that ground if the other party that was not on notice of the interim measure application, they would try to argue that ground. And therefore, what we are seeing in international arbitration is that the arbitrators are simply scared of actually considering ex parte applications. And even if they feel empowered, you know, there is still this risk in terms of enforceability. And as you may be aware, this is called a due process paranoia that has emerged in international arbitration. And we can see in the current version of the LCIA rules expressed provision that after giving all other parties a reasonable opportunity to respond to such application, the arbitral tribunal can do the following, you know, so question the wording of the institutional rules. Do they really help in that goal, in empowering the tribunals to grant those remedies? But of course, it does create issues with ex parte applications. So that's the rationale, and that's what I think we as practitioners may want to consider in the future. Do we need to do something with the existing framework? Is there a need for amendments to the New York Convention? Is there a need for another convention? Turning to ICC Rules 2021, well, Article 28 of the ICC Rules is quite broad, and it says that unless the parties have otherwise agreed, and as soon as the file has been transmitted, the arbitral tribunal may, at the request of a party, order any interim or conservatory measure it deems appropriate. So that's quite a broad power, and again, doesn't limit the tribunal in terms of a type of interim measure it may wish to obtain. And then I would like to come to this sentence: any such measure shall take the form of an order giving reasons or of an award as the arbitral tribunal considers appropriate. And here we come to another point and another potential consideration under the New York Convention. This wording specifically addresses the point that an interim measure can be rendered as an award, and that's precisely for a reason that the New York Convention does not actually provide specifically address enforceability of interim orders. So we are accustomed to think of forcing arbitral awards under it. So in order to make interim measure more enforceable, ICC rules helpfully provide that clarification. But as practitioners, of course, when applying to the tribunal, when submitting your application, one needs to think about whether it's going to be in the form of an order or in the form of an award. Of course, in practice, you'd want to get an award just to ensure more enforceability for the reasons I mentioned. ICSID Rules, Article 26, again, identifies that an interim measure is any temporary measure by which at any time prior to the issuance of the award by which the dispute is finally decided, the arbitral tribunal orders a party, for example, and without limitation, to, and again, listing the types that we discussed. Coming back, actually turning to ICSID rules, that's quite exciting because ICSID rules, as you know, have just been revised, and Rule 47 also has been amended, and we can see the current wording to say that a party may at any time request that the tribunal recommend provisional measures to preserve that party's rights, including measures to prevent action that's likely to cause current or imminent harm to that party or prejudice to the arbitral process, maintain or restore the status quo pending determination of the dispute, or preserve evidence that may be relevant to the resolution of the dispute. And I'd like you to pay attention again to the drafting, very importantly, of it. We can see that here we have a recommendation from the tribunal. It doesn't say the tribunal shall order. So that's a recommendation from the tribunal to do one of those things under Rule 47.1. And when the question arises, when what is it a recommendation? What are the circumstances of non-compliance with that recommendation? And the tribunal in RSM against St. Lucia and ICSID ad hoc committee actually looked at the negotiating history of the ICSID convention, where it was indicated that consequences should attach to non-compliance with the recommendation. So in other words, making it similar to order, but then again, that's an ICSID ad hoc committee observation. We'll see how the practice evolves and how that will be interpreted by the relevant tribunals. And if we look, we've considered a few examples of the institutional rules, and now we come to the national laws that accommodate granting of interim relief. And we have in England, it's Section 39. In Switzerland, it's Article 183 of PILA. Of course, ancestral model law has a quite extensive provision on interim measures in Article 17. So that means that the countries that followed the model law, they adhere to the framework set by ancestral model law in their national arbitration laws. And so again, we have on the screen Article 17, very wide. The arbitral tribunal may, at the request of a party, grant interim measures, again, in the form of an award or in any other form, and a list of the types that we discussed, but also has a provision of a means of preserving assets out of which a subsequent award may be satisfied, or preserving evidence that may be relevant and material to the resolution of the dispute. You see the wording differs, but pretty much the idea is similar. What I think is quite helpful is that ancestral model law outlines the necessary and cumulative conditions for awarding interim measures. And it's important, given that, sometimes it's unclear, and sometimes the national laws would not set out a test for an application for an interim measure. So therefore, it is helpful to have that outlined in the ancestral model law, to say that the party requesting an interim measure shall satisfy the arbitral tribunal that harm not adequately reparable by an award of damages is likely to result if the measure is not ordered, and such harm substantially outweighs the harm that is likely to result to the party against whom the measure is directed if the measure is granted. And that's an important one, and sometimes it's referred to also as the balance of convenience test. And another factor is that the tribunal needs to be satisfied that there is a reasonable possibility that the requesting party will succeed on the merits of the claim, and the determination on this possibility shall not affect the discretion of the arbitral tribunal in making any subsequent determination. That is quite important, because what the tribunal bears in mind when thinking about granting an interim measure, of course, is the tribunal is very mindful of not to prejudge the case at this early stage. At the same time, the tribunal will need to be satisfied that there is a reasonable possibility, there is some merit, that the party will, has a chance to succeed on the merits of the claim. So, and Article 17A of the model law provides safeguards to prevent abuse of process. So, for instance, the tribunal may modify, suspend, or terminate the interim measure at any time. The tribunal may require security to be provided. The tribunal may require a party to make prompt disclosure if there are any material changes in relation to the underlying situation that resulted in the measures being granted. Well, this is quite helpful because, the party should not be misleading the tribunal. If anything material arises that's significant of disclosure, the tribunal may require that party to disclose that. And interesting that it also sets out that the requesting party may be liable for any costs, damages caused by the measure if the tribunal later decides that the relevant measure should not have been granted. Looking at the test for the tribunal-ordered measures, the two requirements have emerged in the arbitral tribunal jurisprudence, and pretty much I would say it's consistent in my view in that regard. And in Occidental and Ecuador, for instance, the tribunal explained that provisional measures should only be granted in situations of necessity and urgency in order to protect rights that could, absent such measures, be definitively lost. So urgency and necessity, I would say, have emerged as part of the test. And Rule 47 under the new ICSID Rules of 2022 incorporates that expressly. Coming back to, a really big question of what happens if a party, the party against whom the measure is granted, is not complying with it. So what are the options to the successful applicant? What happens? Is there any real anything real, any real tool against the party before the tribunal in international arbitration? We know that in England, if you do not comply with the order, you may be liable of contempt of court, and that's a criminal liability. So what about international arbitration? Well, first of all, you could, of course, go to a court. And in case of non-compliance, if you're in England, for instance, you can say that there has been a breach of the order, and there can be contempt proceedings issued. But what if that is not available in the relevant national court? The tribunal may draw adverse inferences, and you have seen the wording of various rules, including the LCIA rules, and where the tribunal may draw such inferences. But for those of you who are familiar with international arbitration framework, it is quite, I think the practitioners are still struggling in terms of identifying the scope of an adverse inference. What is it actually? And one view is that, well, adverse inferences may actually result in the costs award ordered against that non-compliant party, or potentially may even affect the outcome of the case. But again, that's something. Is it enough? Can we do something more? Or would the tribunal really draw adverse inference in case of non-compliance? Would they be empowered and confident to do that? So, but these are the issues, of course, that we are, as practitioners, thinking about. Helpfully, Article 17H provides that an interim measures issued by an arbitral tribunal shall be recognized as binding. Well, it is quite helpful, to have that clarification. And I think the national laws that have that, I think is quite a welcome point. Because again, given the nature of the interim measure, given the temporary nature of it, in order to enforce it, the enforcing courts will look into the finality of that interim order or award. And as we mentioned, a third way, so if we have a situation where the tribunal hasn't yet been constituted, there is now this figure of emergency arbitrator. And I mentioned the LCIA rules and the ICSID rules, but pretty much emergency arbitrator is the sole arbitrator who's been appointed upon an application. If we take the LCIA court, upon the application to the LCIA court, the LCIA court will then consider within its pool candidates for an emergency arbitrator and will appoint it within 3 days of receipt of the application, or as soon as possible thereafter. And the idea is that the emergency arbitrator will decide the claim for emergency relief as soon as possible, and to facilitate that speedy process efficiency. Article 9b provides for the framework of 14 days, no later than 14 days following his or her appointment. Of course, the deadline can be extended by the LCIA court in exceptional circumstances, or by the agreement between the parties. And when considering that application, there may be, especially in the cases of exceptional urgency, there may no need for a hearing. So actually that application can be decided on paper. And again, the form may be in the form of an order or a word, but it must give reasons for the decisions. And why? Because if it's unreasoned, it may again affect enforceability of that order or a word at a later stage. So as we discussed, so we're coming back to big questions again. Enforceability under the New York Convention. The known, there is no reference to interim measures, to enforceability of interim measures, orders not covered by it. Interim relief is by nature is interim, it's not final. So can we do something more to facilitate enforceability of interim relief and empower the arbitral tribunals to grant them? I would suggest that we think about it and continue our discussion after this presentation as well as a community. And just to state the obvious in this final slide that, of course, if the tribunals do not have the applicable framework that empowers them to grant the interim measures, the party may have no choice but go to the court. And national courts may need to intervene and determine a request if they decide that the tribunal does not have that power to grant interim measures. Or again, where there is no other possibility before the tribunal is constituted. Although note that in England, the case law has evolved to say that there is an emergency arbitrator mechanism available. So therefore, the first point of reference should be the tribunal always. Well, the third point, of course, is that if a party wants an ex parte relief, as discussed, there it is a little problematic, but it doesn't mean that it's impossible. Another point to mention is that third parties orders, if there is an order that is made against a third party in case of a freezing injunction, for instance, against a bank, what is again how enforceable will it be if it's granted by the tribunal? And the current framework, I think, makes it clear that the courts are more empowered to grant orders against third parties because there is a big issue around third parties in international arbitration, as you know. And again, interim measures may not be enforceable, and as a result, a party may need to request an order from a court in the relevant jurisdiction. So on that note, I'd like to conclude and potentially also, of course, open the floor to the questions from the audience.
Now we will take some questions. What happens when an order by an arbitrator is not compiled with, especially before the commencement of arbitration?
Well, that's again coming back to what happens, what can be done. If you are the party, the successful applicant, you'll want to ensure that there is something in place that provides for that basically confirms the non-compliance and the breach of the order. It may be by way from you can go to the court to start contempt proceedings, or you may just when the tribunal is constituted, ask to draw inference against that non-compliance. But pretty much these are the two options that are available, and it will depend on the courts and also the tribunal how far they can go in terms of ordering the sanctions for non-compliance.
Participants, you all can ask questions from the speaker in the chat box. Are there any work in progress to clarify the position of ex parte applications?
There are ongoing ancestral working group sessions on it, and there are a few reports that have been discussing that issue. But I think there is nothing that's actually from my knowledge that's ongoing that is going to change the current framework. So that is something that is I'm quite passionate about as the topic, as well as actually potentially suggesting something as well to the wider community. I mean, there has been, of course, lots of discussion around it, but in terms of specific steps taken, apart from all these working group sessions and papers, I don't think so, unfortunately, not at the moment.
What will be the implications or applicability of the interim order on the arbitration in maybe other country?
In other country, do you mean it may be referred to as the in, say, IC, maybe that is a situation when, say, in the investment treaty context, sometimes you have ongoing local proceedings elsewhere, and the tribunal may want to consider, an order, or the parties may apply for the order to restrain other courts or other proceedings from taking place pending the final resolution of the arbitration. So that's it. If that is what's referred to, that actually, again, within the wide scope of powers, it is possible. But how confident the tribunals will be in granting those measures depends, basically. But they have been a successful example, say, in the case in Merck Sharp against Ecuador, where the tribunal granted measures restraining enforcement of any local judgment against the claimant. So there have been a few successes on that.
With such reliefs, isn't arbitration coming closer and turning into the traditional adversarial system?
Well, so is the starting premise that arbitration is not adversarial? I would say that, international arbitration, say, as opposed to other means of dispute resolution, and of course, in the context of mediated guru, if we're talking about mediation, it is adversarial. Arbitration, it is inevitably inherently adversarial, like any other form of binding dispute resolution mechanism. But I would suggest that if the courts have the power, and international arbitration that's becoming, so widely used around the world, really is not yet fully equipped to deal with those, does it mean that it's somehow inferior? Potentially. That's my question. I hope I answered with a question. It's not helpful, but let's see what we have.
What important amendments to the NYC 1958 need to be made?
I think that's such an important question, and of course, basically it is. So some practitioners, some arbitration practitioners take a view that there is no need for those amendments because it is workable, and in fact, of course, it has ensured enforceability of many awards around the world. What I would, in the context of the current presentation, I would think about introducing potential provisions on interim, specifically measures, interim orders, and possibly either by way of an amendment to the convention or maybe drafting something else. But of course, there is the new convention in place already. We have seen 0 amendments to it. I think it will be a very tricky process, but nonetheless, something I think with the fields emerging, something that needs to be thought of, and just clarifying that scope and looking at potentially Article 5 of the new convention from the point of view of enforceability as well. Great. Garima, do we have any other questions?
Yes, ma'am. We're just waiting for the participants. If they have any other question, they'll just write that in the chat box.
Mm-hmm. While we are waiting, maybe I will just mention that in my practice, I have got a successful application of security for costs before the tribunal and succeeded for the respondent. And I think, again, that when we got it, it made me think, there is this preconception or maybe a myth as well that exists that it's very hard to get a security for costs, for instance. But I think unless you ask, you won't get. So actually, that tribunal, in our case, was very comfortable in issuing that. And I remember when we were preparing that application, I looked, say, at the CIR guidelines on security for costs, and they were extremely helpful. But, I think just as to take it to another level, okay, we understand that the interim measures are possible. It is available as a mechanism, but can we make it more enforceable? How do we do it? Does the current framework accommodate that? These are really the questions that I'd like you to think about as well.
We got no more questions. Does third-party funding vitiate interim measures?
Pardon?
Does third-party funding vitiate interim measures?
Does it? So sorry, I didn't quite catch that. Does it cover? Sorry, would you mind? Sorry, Anushka, would you mind repeating that?
Yeah, ma'am. My question was, does third-party funding vitiate interim measures?
Cover interim measures? Does it? Sorry, maybe I will just
Make it less effective.
I see. Sorry, I didn't catch that word. It may be
Yes.
it may be the connection. Third-party funding. Well, of course, if you look at it in the context of in the context of security for cost, that's something that I could think about in terms of, where third-party funding can be relevant in considering applications for security for costs. And, the person who asked this question may be familiar. There is this jurisprudence in the investment treaty arbitration that that say that it may be a factor, or there is now a different view. I think that, in my view, of course, all factors need to be considered before the tribunal, including the ability to pay and satisfy the adverse costs award. But I wouldn't consider third-party funding per se to be as a factor that will help, will just be a sort of like a determinate factor in granting the security for costs, for instance. And I don't think it should be, because as we know, third-party funding is now being obtained by not just impecunious claimants, but also for the purposes of risk mitigation within the corporate groups. So I wouldn't say so. I think that's the answer.
Okay. Thank you, Ms. Uliana, for such a vibrant, interactive, and knowledgeable session. I would also like to thank all the participants for joining us, and I would request everyone to please fill up the feedback form before you leave in order to receive your certificates. Before we end the session, I would like to announce that Mediate Guru is organizing Second International Arbitration Moot 2022 in collaboration with Luthra and Luthra Law Offices, hosting university International University of Sarajevo, hosting institution Vivekanand School of Law and Legal Studies, supported by Careers in Arbitration, Racial Equality for Arbitration Lawyers, Digital Coffee Break in Arbitration, Moot Alumni Association, Rising Arbitrators Initiative, supporting law firms, Naom Legal, Sharma Mediation and Arbitration. Registrations are open now. Don't miss out this opportunity to compete with global teams and get practical learning in the field of ADR. Thank you everyone for joining us.
Thank you.